Hi, everybody. This is Jeremy with nVest. We're going to wait just a couple minutes. I'm on live a couple minutes early today, just to make sure that we're going to have to do a quick setting change, real quick. That's why we need to check it ahead of time. Okay, so you should be able to hear me, but I'm not going to hear the echo of myself, which is what I was concerned with. Okay, we're going to go live here at 7 p.m. Mountain Time, Tuesday, May 1st. I want to welcome the clients who will be watching us live tonight. I know a lot of clients have already told me that they're going to watch the replay. Not a problem. I appreciate you guys logging in. This will take about the full hour. If you get here a little late, this is why we're going to have a replay so that you can catch up with it. Please make sure, a couple of things, that you download the workbook that goes with this webinar, and we're going to have it available for you. It was in the link prior to the start of this webinar. If you don't have one and the link's not available or you can't find it, don't worry. Just email me and we'll send you a copy directly. You don't need it to take notes tonight. It's not like a fill-in-the-blank kind of workbook, but it will let you take some notes, and it will be a hard copy of a lot of the information that we're going to talk to you guys about tonight, okay? If you join us late, you'll find out. You'll be able to back this up. We actually have YouTube set up as a DVR tonight also, so that you can rewind the webinar to whatever point you need to pause or take a break or whatever and come back to it. But I really want to appreciate and say thank you to the clients taking this part of your financial life seriously. Tonight's webinar is, again, all about basic estate planning. That sounds like a really awful subject. I'm going to try to make it fun, but I wanted to make sure that you guys know that there's probably not more critical things that you can do no matter what stage you are in your life. Okay, I'm going to switch to a screen share. We're going to go through some PowerPoints together, and I'm going to walk this with you. So get comfortable, sit back, make sure to take some notes. If you have questions, I'm not going to be able to see your questions while I'm doing the PowerPoint presentation. So jot them down, or you can put questions on the main screen that you're on right now, and I will get to them after the webinar and respond to you personally. Okay? Hopefully, we will be able to knock this down in short order. So let me just swap screens for just a minute, and we will begin our presentation. Okay. So tonight's webinar is, again, about estate planning basics. And this is part of, and I'll get to the screen in just a minute, but we invited all of our clients, no matter what stage of life you are in, to attend this one. This is the first of a series of training videos that will eventually branch out and train you guys on things that are important to you at your particular stage of life. All right. But at the moment, we're going to be talking to all of our clients about this very, very serious and important topic, probably one of the most important things I can talk to you about. So here's a quick note, though, because sometimes these are on YouTube, even though we've made this private. Sometimes people can find it. This webinar is intended only for current clients of nVest Advisors. We are registered in Colorado and Texas, so most of the information has been tipped toward Colorado and or Texas in terms of estate planning. We do plan to have, within the next week, a public version of this that will be on YouTube that you can watch at any time, or through our website. But in the meantime, if you want to see what's available for you as a member of the public, just go to nvestadvisors.com. We have a button at the top that says blog and events. Just click there and you'll be able to see what's coming up or what we already have in the archive for you, okay? All right, let's get started. So for our clients tonight, this is really kind of a fun thing because I get to finally explain in person, if I haven't yet, with you what this investor life cycle program is about. About 6 months ago, we grouped each one of you into one of, was originally 3, and then I added a 4th, what I call just like a basic group of investors. So you are either an early investor, an emerging investor or an established investor, and we've since added now, because we have 401k plans that we're the plan advisor for, an employee investor. And that's really like all we have with you if you're an employee investor is the relationship through your company. We offer other services to you, but we don't have the one-on-one planning relationship with you that we do with our other clients. But based on your current financial life and where you are in terms of age and investment experience and account balances and things like that, you were grouped into one of these different investor life cycles. And as you graduate from each life cycle, you will move up to the next one, and we will be able to talk to you about very specific financial and legal and tax issues that usually affect people in your life cycle. So once per quarter going forward, this is the first one, we're going to focus on one specific financial subject for you people in your life cycle. And I'll show you what's coming up for Q3 of 2018 at the end of the webinar. But that's pretty much the way that we will work with the investment training that we do in between our normal client appointments with you, okay? So here's how to make the most out of our webinar today. Please take notes in the workbook. And this I noticed as I put this picture up, this is the screen cap of the cover of the workbook. I should have made this a lot flashier, sorry guys, but you have about a 30-page workbook that we put together for you that is of the different slides of this particular webinar in a lot more detail than I can go into in an hour. So please, if you don't have one of these, please email me and we'll send it to you so you have a copy, okay? And then we'll make sure when we do the replay for our clients that the workbook is actually attached there as a downloadable link already, okay? So this is the first thing you need to do is make sure you take notes and write down your questions that you want to talk to me about for your particular situation, okay? Second, follow up with me after the webinar with just a 15 or 20-minute phone call so that we can strategize about what's missing from your estate plan, and we can put a quick plan of action together to knock these things down to make sure that your family's financial situation is taken care of, okay? And then I will put a link. There actually already is one on the page you're viewing of a link to schedule your estate plan call with me at the end of the webinar, and it's already there. You can click it at any time. Don't schedule now. Watch the webinar. It's important. And the third thing is let's actually honestly obtain, execute, and upload your financial documents. You can upload, your estate plan documents. You can upload them to the client portal, and we will create a folder of just estate plan documents for you. And we can even allow your CPA, your lawyer, or a trusted family member to have access to just that folder so that they could ever access your financial or your estate plan documents if something ever were to happen to you, okay? So we'll work those things together over the next couple of months until the end of the quarter. I hope to really get a whole bunch of our clients done in terms of estate planning by the end of the quarter, and we're just going to work on these things together, guys. We're in it together, okay? Now, a lot of people are asking me sometimes, why would I even bring the subject up? Because it is like the last thing you want to sit and listen to on a Tuesday night is about death and dying and all of this kind of tough stuff. It's a grown-up subject for sure, but one of the primary reason is, and I'm sure you all remember when I would ask you as you became a client the first time, one of my first questions is, do you have a will? And I was thinking before I gave this webinar, I bet you 80% of you said no. And we all made promises, yeah, we'll do it. And very few of you have done it, at least to my knowledge, because every year at the annual review, we ask the same question, do you have a will? And most people are still telling me no. So this is why I decided that we would make sure that all of our clients got this experience and training at the same time, okay? And here's also why, from a national perspective, most people never get one, okay? Over half the total population, forget even a full estate plan, 55% of the total population never get a will in place. But what concerns me more, especially because we have clients in South Texas, is 74%, almost 3 out of every 4 Hispanic families never get a will. Okay, 68% of black families, about half of white families, and the other one that really concerned me, because most of our new clients are younger families and younger people just getting started in their lives, 92% of people under the age of 35 do not have a will in place. That's scary because most of those people are the ones with minor children. Okay. Now, when they ever survey people about estate planning and they ask, why didn't you or why don't you have a will? The top four answers we get, and they're almost a statistical tie. They're very close in terms of how much people are, which excuse kind of we make. But these are the top four reasons people say they don't get a will. Either you don't need one, it's too complicated, it's too expensive, or you make the erroneous judgment that my spouse and my kids are going to get everything anyway, so why do I need a will? On a more personal level, we've had several instances in the past 2 years in our own nVest family where a better estate plan would have really helped a family when they needed it most. And I can't give you specifics on a lot of those events because of client confidentiality. I would never violate that. But I can certainly talk about my own situation. And I'm sure some of you will remember in July of last year, this twisted wreck was me and 3 of my family members. Okay, we were just coming home from a day in the mountains. We were nearly killed by a truck that hit us broadside. In fact, when I was posting the photo, I noticed in the upper right-hand corner of that photo, you can see the truck that hit us. They towed it to the same place. So that white truck in the corner is the one that actually hit us. Although by God's grace, all 4 of us came out of it relatively unharmed, at least with long-term repercussions. But if any of us had been killed or severely injured or debilitated in that accident, the only member of the family who was not in the car at the time was my 19-year-old daughter, Sarah. And Sarah would have been arranging funerals or dealing with complex medical care, maybe having to sell a house, sort out financial situations, dig up every account, settle accounts, pay bills, etc., at the age of 19. And if all 4 of us had been taken in that car accident. So by God's grace, we're all doing great. But at any moment, none of us knows what's coming. I eat well. I exercise a lot, keep myself in really good shape for a guy in my late 40s. But in an instant, this happened. And guys, none of us saw the thing coming. No one in the car saw the truck. Okay, so this is one of the reasons why we need to make sure that we plan for the what ifs that can happen in our life. And honestly, here's why. Because when at nVest Advisors and as your financial advisor, I believe very, very strongly that you should never, never, never be a burden on the people that you love when you had a chance to do something about it first. Whether that is planning for retirement and building your own savings, or getting out of, or looking at long-term care costs as you age, all of those things, or creating an estate plan so that your family is better off for your foresight and your grown-up discipline than to just leave it to the fates and let things happen. Okay, so that's one of the reasons we're doing this tonight, and why I'm going to nag you ever so lovingly, like I do, to get your estate plan in place. So here's the first question everybody would ask me is, then what is an estate plan? It's very simple. It's just a map created by some legal documents of detailing how you want your personal and financial affairs to be handled in the case that you are incapacitated. We're going to talk about that, or death. Okay, and it's a combination of things like a will, a trust, things that are necessary for your personal situation that will make sure that your loved ones understand and know what your wishes were in case you can no longer speak for yourself. Okay, that's as simple as it is. So don't be overly concerned about that this is a very technical thing, I mean, yes, we want to make sure it's done correctly, but it's that simple. This is just a way for us to plan ahead and make sure that we are able to tell people what we want and what we don't want and what we care about. Okay, so who needs an estate plan? I am sure, because we have a client base, although we have very wealthy clients, most of our clients are either younger or still working families, blue collar workers, small business owners, school teachers, just working professionals. They're not the mega wealthy. They don't have all sorts of like trust funds and things that they're living off of. I get it. People would say, well, I don't know that I need it because we don't have much. Well, the chances are you actually do need an estate plan. Okay. You can think that estate planning is just for the wealthy, but it is not. In fact, an estate plan may actually be more important if you have a small estate, because your final expenses, when you don't have much money, will be a much bigger impact on your family. And there's a much greater possibility that your loved ones are going to suffer from a lack of financial resources than somebody who's very wealthy. Okay. The fact is, without an estate plan, you cannot control what happens to your property if you die or become incapacitated. Now, generally, people create estate plans because they want that control. They also want to make sure that their wishes are clear in order to avoid family disputes. And I've known people who have had very complicated estate situations because the family starts a war over things. Okay. It's funny what families will fight over. The photo on the wall that no one cared about for 25 years, now they care. Okay. In addition, a lot of people are worried about preserving their property for their loved ones. They don't want to lose it to, probate or something like that. So they just want to make sure their loved ones are properly provided for. Okay. So now here's some specialty reasons why you'll need an estate plan. So it is especially crucial that you have an estate plan, regardless of how much you have in terms of assets right now. If, for example, your spouse is not the one who's comfortable making financial decisions, if you are always the person who does all the money deciding in the family and something happened to you and your spouse is not comfortable with financial matters, it is very, very important that you have an estate plan. If you have minor children, it is critical that you have a will in place to protect those children. Okay. If you have a large estate and people look at that number and go, oh my goodness, I'm never going to be worth 11 million. You'd be surprised how fast, if you own a business that's successful or a family farm or several, like you're an investor in commercial properties or something like that, how fast your net worth could grow to 11 million. And you're going to see later in the webinar, certain things get added to that number that you might not expect. So it's actually not that difficult to get to those kinds of numbers if you are financially successful just in general in your life. Okay. So if you have a net worth that exceeds those federal transfer tax limits, right now it's 11,200,000. Or if your state has a lower exemption amount, you need to make sure you have an estate plan in place. If you own property in more than one state, it's critical. Okay. Let's say you own a house in Ohio and you own a winter place down in South Padre Island. If you own property in more than one state, you have a very critical need for an estate plan. Okay. Some people, this is a concern because when you leave your estate to the court system to sort out, all of your financial data becomes public knowledge. And so if you have a need for financial privacy and you just would like to keep your affairs out of the newspapers if you're someone prominent, it's important to have an estate plan. And it's also absolutely critical if you own a business, especially one that you would have to try to like wind down in some way. Okay. Does that make sense? I wish I could see my audience faces and we can know. So now here are the estate planning concepts I'm actually going to talk to you about today. It's basically two areas of concern. Okay. The first one is planning for incapacity. So we're going to briefly discuss your health care as a concern, and also we're going to look at property management. So this is not if you die, but this is if you are in some way incapacitated and can no longer make decisions. Okay. We also are going to talk about planning for our inevitability. We're all going to shuffle off this mortal coil. Okay. And when we plan for death, we're talking about things like wills and probate. We're going to touch very briefly on taxes, and I promise I won't beat that to death too much. And then we're going to talk about ways that people can avoid some taxes, which is things like lifetime gifting, life insurance used in a trust or in an estate planning capacity, and also trusts. Okay. So we're going to be talking about quite a bit of these things today. So let's talk first about what happens if you are incapacitated. And the reason this is important is because I would like you to remember that photo of that twisted wreckage. They had to cut us out of the car, and imagine that that was you instead of me. Okay. Just like me, that accident happened without a second of warning. It came out of nowhere. So incapacity can happen to any of us at any time. And thankfully, I was really just kind of knocked senseless for a couple of days, and they had me in ICU to watch me for 2 days. But if I had been, for example, knocked into a coma for a period of months, how would your doctor know what medical treatments I would want or I would not want if I can't speak for myself? And in your case, the same thing. How would your personal business be transacted? How would bills get paid, for example, if no one is authorized to ever sign a check or documents for you? Okay. What would happen is this, and this is the truth. Someone would have to go to court and get legal permission to do things for you. Okay. And that person, who is called legally a guardian at that point, and is usually a close family member or a spouse or a child, something like that, would have to go back to court every single time they needed to get permission. Okay. Every time that your family needed to sign something for you without some sort of a durable power of attorney, we'll talk about that, they'd have to go to court to get permission to speak on your behalf. Now that can cause huge hardships on that loved one that you did not intend. But here's the other problem. Sometimes your guardian is now making decisions that you've never discussed or put on paper about things like your medical care that you may or may not have wanted. And they may be making decisions that you would never have asked for, you would never have wanted, because they love you and they value your life. And you would say, you know what, I would not want to be, hooked up to a respirator for the rest of my life. But your loved one says, I really don't want to let them go without your explicit consent and writing and your instruction. Your guardian has to make those gut-wrenching decisions on their own. Okay, that's one of the reasons it's important. So when we are talking about planning for incapacity, and again, we're talking about two different things. One is about your property, which I'll get to in a minute, and the other is about your healthcare directives. So I'm going to talk about those things first. Okay, and basically, when we're talking about we're going to talk about 3 documents that are usually used in the preparation of, or at least getting our medical wishes put down on paper, and they are a living will, okay, and they are a durable power of attorney, sometimes called a healthcare proxy in some states, and there's a do not resuscitate or a DNR order. Okay, now let me talk about each one very quickly and what they are. So a living will is a document that lists the types of medical treatment you would want or would not want under certain circumstances. Okay, for example, your living will might state that you do not want life support if you are going to be in a persistent vegetative state. Okay, with a living will, you have to, this is the only downside to this, is you have to really sit and think about all the possible scenarios where you would want specific things to be done or not done. And then you have to put your wishes in writing so that the reader will clearly understand them. So living wills, and a lot of lawyers already have these things up where they ask questions about, certain medical procedures and certain things like that, and they're already kind of pre-built. But you really have to think about, what would I be okay with in terms of long-term medical care that if I'm not able to speak for myself, and what would I not want? So living will is, you hereby declare these things will and will not be done to you. Okay. Durable power of attorney for healthcare, or the healthcare proxy, instead of you making those decisions, if you put this document in place, this lets you designate one or more family members to be trusted individuals. They are now called agents. Okay, and they will make medical care decisions for you. So now it will be that you make sure your medical decisions are done by your spouse or your child specifically, or someone else, but you designate that person so that if things come up that your living will just did not think of or did not include, you can make sure that that person makes that decision for you. So unlike a living will, this type of healthcare directive doesn't require you to go through and like imagine all the possible circumstances. You're simply giving someone authority to make decisions for you. Okay, so that's the second one. Now, a do not resuscitate order is used for a totally different purpose. So let's say that you're in a hospital, you're lingering, you're suffering with a terminal illness, and you don't want the hospital staff to take drastic life-saving measures if you suddenly go into a cardiac arrest. Let's say that, okay? To make sure your wishes are carried out, you may be able to get your doctor to issue this particular form, a DNR, a do not resuscitate order, okay? It's a legal form that's signed by you and your doctor that's posted literally by your bed, and that gives the staff members there, the nurses, et cetera, the permission that they need to carry out your wishes, okay? Without this form, even if really there is no hope of recovery, they must exhaust every possibility to resuscitate you. So this is a form that a lot of people will put in place saying, I no longer want to have my, I don't want my chest opened up and my heart massaged if I'm 95 years old and my time is up. I don't want you guys to go through that effort. Okay. So be careful, by the way, when you're using a DNR, because some states require their own DNR form. So don't just, shop the internet and grab one, a PDF, and fill one out. Make sure that you're getting one that's legal in your state. And by the way, some states require one DNR form for your hospital and another DNR form for a nursing home. So just make sure that you check on your particular state and make sure, okay? Be aware also that not every state recognizes some or all of these tools, okay? So depending on your state, you might need one of those health directives, two of them, three of them, all of them, you might need it. So make sure that you know, okay? Now I'm going to switch gears really quick and talk a little bit about property management. So again, we're talking about if you are incapacitated and unable to make decisions for yourself in terms of financial transactions or managing your property in some way, here are some of the tools that you can put in place to make sure that these are done, okay? The easiest one, obviously, is to just make sure that all of your financial accounts have joint ownership, okay? Joint ownership is that the joint, and that's why they call it a joint checking account. That's a legal term that they add to that account so the bank knows what's allowed and what's not allowed based on the signers. So in a joint account, the other owner has the same access to the property that you do. For example, if your joint checking account with your spouse or significant other means that either one of you can make deposits, write checks, get statements, etc. It's just treated like either one of you is the only owner. So in the case of when you are incapacitated, your spouse, if you have a joint account, no problem. Your spouse can just take the money and do what's necessary from day one, okay? Durable power of attorney, though, is sort of like the one for healthcare. This just lets you name a family member or a trusted individual to make financial decisions or transact business on your behalf, just like with the one for healthcare, but this is just a plain financial and property management power of attorney, okay? So that was done, for example, when we first moved to Colorado. My wife could not be here not be down in Brownsville for our home closing there, and I could not be here for the home closing in Colorado. So we had issued what are called limited power of attorney for that particular transaction so that we could sign for the other party in the different states, okay? Living trust is another kind of really common strategy that I see a lot in financial planning and estate planning. I'm going to talk more in detail about trusts later, and I'm not going to really beat trusts to death tonight. I'm just going to give you kind of a flavor of them. But for now, just know that a living trust can be used for planning and incapacity because somebody who's called a successor trustee can step into your shoes and manage the property in the trust if something should happen to you. So you have the ability at that point to put property into a trust and then let the trustee manage it according to very specific instructions. So again, that's different than joint ownership or durable power of attorney, because in those two situations, the person who is either the joint owner or your agent can do whatever really they want. They're acting as you on your behalf. is very specific rules that you created that says what to do with property. And the person who is running the trust is called a trustee, and they have to follow your instructions. Okay, so that's really about incapacity tonight. If you have questions about that, make sure to write them down so we can move on now with the other part of tonight. What happens if you die without an estate plan? Okay, all of us make plans that are based on the possibility that a specific event's going to happen. Okay, many of us carry more than, for example, the minimum amount of car insurance because you recognize the chance that financial loss, sometimes substantially, could result from an accident. You buy life insurance because something could happen to you while you're still working and your family requires your income. Since it is 100% certain, I wish it wasn't, but it is, that each of us is going to die at some point, you might think that everybody would just say, oh, look, the logic is we should have an estate plan. That is not the case. So what happens if you die with no estate plan? Okay, if you own property jointly, like we just discussed about joint accounts, that property is going to pass automatically to the joint owner when you die. Okay, if you have an IRA or your retirement plan or you own life insurance, those kinds of things will pass automatically to whoever you listed as the beneficiary on that account when you die. Okay, also property that is held in a trust will go automatically to the beneficiary that you listed in the trust. Okay. In general, though, how the property will pass according to state intestacy laws. I'm going to talk about that very briefly. So what are intestacy laws? We'll touch them in a minute, but these laws are put in place to dispose of property that somebody dies without a will, or with a will that was written long ago and before you bought your vacation home and you never put it in the will, so the court, nobody knows what to do with this extra property because it was not in your will. So there are laws in every state to handle that. Those are called intestacy laws. Okay, let me click ahead here. My computer's getting slow. Okay, so let's say that you die. I'll just make this kind of a sample, an example. Let's say you die, then you're leaving $5,000 in a savings account. Okay, where does the money go? Who does the money go to? Without instructions from you, the money will go to the person or the people that your state's laws say it's going to go to. Regardless of what you would like to happen, the law is going to follow the law. So intestacy laws, it's very important to understand, they vary from state to state. They are not federal laws, okay? But you're going to be able to see here, excuse me, a typical pattern of how they're distributed. Normally, and this is kind of, again, broad brush generally, 50% of your property will go to your spouse and 50% to the children. And again, remember, it could be different in your particular state. So the biggest issue with just leaving it to intestacy laws to take care of is that your actual wishes are totally irrelevant. So let's assume you live in a state that has the intestacy laws that look like this with the 50 and 50, okay? Without an estate plan, regardless of your wishes, for example, let's say you wanted all of your property to go to the spouse and none to your children, your estate would be divided evenly between spouse and children, no questions asked, okay? Now, there are a lot of potential problems with allowing your property to pass by what's called intestacy, okay? For example, the distribution pattern imposed by your state's intestacy laws could result in family fights, disputes among the heirs, the overall taxes could be higher. Intestacy is also a really problematic situation for unmarried couples, for gay and lesbian couples, for people that maybe get together late in life but decide to keep their estates separate, okay? Since intestacy laws do not include, usually, unmarried partners when they look at the distribution of property, okay? Good example is if you were with a person, you were planning to get married, you weren't married yet, or maybe just living with someone, but you would want them, to help them if something happened to you. Without a plan, in the state of Colorado, for example, if you have no spouse, actual legal spouse, and no children, the money would revert to your parents automatically. So there's a lot of weird little laws like that your money could go someplace completely where you did not expect unless you take care of it. Okay, there's a very simple way to avoid this, though. Create a will. So we're going to talk again about a will here in just a minute. Now, please remember, like I just said on the before, intestacy can be very messy. Spouses do not automatically inherit everything in most states, and don't assume so. The other problem is anybody can attempt a claim on your estate without a will and that kind of thing. And there are actually, I wish I was kidding, very sketchy lawyers who spend all day looking through the obituaries, finding someone who's passed away, and filing a totally frivolous claim against their estate, just seeing if they can get a few $1,000 out of the estate. I wish I was kidding. It actually happens. Okay. The other issue is state laws. If you, especially have property in multiple states, like we know a lot of our winter Texan clients do, state laws can vary widely. So if you leave it to the fates, you have two different state governments dealing with it. Okay. Now, I did not get into specifics on each of the two states tonight because they were so complicated, the intestacy laws. I was going to list out for you, if you have this and you don't have this, here's what happens, et cetera, et cetera. But even just doing Texas and Colorado was crazy. So I wanted to give you this link that you can go to. Nolo.com is a very good, mostly free legal website that you can look over and get a lot of information. But this one will actually, not just wills, but they'll actually talk about all of the different estate planning specifics for your state. And we will review these. And when we talk to you personally, as I know what state you live in, we'll make sure that the estate plans we put in place for you are state compliant. Okay. So let's talk about the things you can do before you get a will. Because I've nagged everybody for wills for a long time, but now I'm going to talk to you about the things that you make sure we do and we check up on a regular basis. This can save your family so much hurt. I can't tell you. This has literally happened in our practice just this last summer with a gentleman who passed away, who was a 401k participant with us, did not have any beneficiaries on the 401k, had minor children. They needed to get to his 401k for money to bury him. And the ex-wife came to make a claim. Okay, so these things happen, guys, for real. So here's some things you can do right now that will protect a lot of your assets without even doing a will. Number one, please review and update all of your beneficiaries on any and all life insurance, annuities, and any retirement accounts. All of those allow you to put beneficiaries, and most of them require you to put beneficiaries on those accounts. Okay? Now, one thing that people are usually not aware of is you can also add what are called transfer on death or payable on death designations to all of your remaining financial accounts, like your bank and checking, savings, CDs at the bank. If you have a taxable brokerage account, you have an employee stock option account, you can add what are called TODs or PODs, and it depends on which institution you're talking to. You can put them on. So it basically adds beneficiaries to those accounts as well. That means when there's beneficiaries on them, they go right to the person you intended without having to have a will and without having to go through probate. Okay. Now the two, just so you know the difference, if you go to a bank, they are called payable on deaths because you're dealing with cash. So it's just cash. It goes to the person you want. If you're dealing with investments of some sort, gold, stocks, that kind of stuff, because the person doesn't necessarily have to sell the stock, they can just receive what you owned. That's why they're called transfer. So we can transfer stock, but we just pay out cash. And that's why they're called different things, okay? So let's talk about wills and probate. If I were to ask my clients, I wish I could have a hand raising and have all of you in one room. How many of you have your will yet? I would still bet 80% of you do not, okay? But a will has got to be the most vital piece of anybody's estate plan. And if you only started and stopped with a will, you are better than more than half of American families in preparing your family for something awful that may happen, okay? So here's what a will is if you don't know. A will is just a legal document in which you direct how your property is going to be distributed when you die, okay? Simple as that. It also lets you name somebody as what they call an executor who will carry out your wishes, which are stated in your will. So all they're doing is doing what you wanted done when you're no longer here, okay? Also, you're going to be able to name a guardian for minor children in a will, and you can also create a trust in a will, okay? You can use your will to do other things, accomplish other estate planning goals too, like tax planning. is a good thing that can be done inside the will, actually. Okay. Now, to be valid, you can't just write a will on a sheet of paper and say, I'm done. To be valid, your will has to be in writing. You can't speak it. Okay. And it has to be signed by you, but your signature's also got to be witnessed. And the number of witnesses varies from state to state. Some now also require that it be notarized. Probably not a bad idea anyway, to make sure you have it legally notarized. So these requirements are important because if you're not careful, the will could be considered invalid in court. Okay, so I will give you some options, some do-it-yourself options when we talk, but I will also tell you that if you have a complicated situation, one of my advices will be that you consult with an estate attorney to get these documents done. We have one in Texas and we have one in Colorado. They are not as expensive as you think to get this done properly. And there are attorneys that I've worked with for a long time, and I'm very happy and comfortable that you will be treated right and that you will get these things done properly. Okay. So now, excuse me, there's like one big consideration to having a will for some people, and that's that wills usually have to go through a process called probate. So I'm going to explain probate to you in the next slide or two. Okay. Most wills, even if they're properly executed, they still have to be probated. And what that means is that and I can also say the rules can vary from state to state on that, but in some states, like if your estate is very small, that your will may be exempt from probate. They just won't bother if it's like my house, my car, the stuff in my house, and my checking account. If it's a small thing, some states really don't require probate, or they do have an expedited process for very simple wills. But probate starts when somebody will after you die, they file your will with the probate court, okay, which will then oversee the rest of the settlement process, they call it, of your estate. So usually the person who you put as the executor in your will is the one who takes the will to the probate court and files it. Okay, so once the will is filed with the court and it's validated, the executor then, your executor, can then go about the business of settling your estate. And this means that you collect money owed from the person to the person who died, such as like your last paycheck. Maybe if you're a landlord, rent checks, that kind of thing. The executor will pay any outstanding bills that are in there. They will file your final income tax and maybe possibly estate tax returns. And then if necessary, distribute all the remaining property to the rightful heirs. Okay, that was listed in the will. Now, usually everything goes pretty smoothly during the probate process. It usually lasts anywhere from a couple of months to maybe a year, depending on the size of the estate. And also if there's things that have to be sold at, and find a buyer for, and there's like real estate, it doesn't sell always right away. So, and as long as the executor does what needs to be done in a pretty timely fashion, and there are no family fights, the probate process is usually pretty quick. Okay. Nevertheless, some people still really want to avoid probate. Okay. So let me give you examples of why you might want to avoid the probate process. Okay. First, let's just look at why it's okay. Probate's not that awful. Okay. For most estates, there's usually no reason really to avoid it. The actual time and costs are usually pretty small, and it just doesn't make sense to, or expense rather, to plan around it. There's actually a couple of benefits from probate. Here's a couple that I think are something to consider. Because the court supervises the probate process, you have some promise, or at least some assurance, that your wishes are going to be abided by. And if some family fight does come up, the court's going to settle the matter, and the courts are usually pretty final. Okay? Also, probate offers some protection against your creditors. This is part of the process. The court or the executor has to publish a public document, usually in a newspaper, that says that anyone with a claim against your estate, so a creditor, has a certain number of days to file their claim. If they don't in that time period, it's really, really hard for them to come back later and try to make a claim against your heirs. Okay, so that's one way that probate actually helps protect against creditors. But in some cases, Probate can be really burdensome. It could take up to 2 years to complete if you have a complex estate. This could tie up property that your family might need immediately, and it's also going to cause costs that go way, way up, such as executor fees, attorney's costs, insurance fees, etc. Okay, and if you have real estate in more than one state, like a summer home one place, a winter home in another, your executor is going to have to file your will in the probate courts of both states where the properties are located. This is referred to as an ancillary probate, and that can take a while. Okay. Also, wills and any other documents that you submit for probate become part of the public record, which can be maybe not what you want if a family has privacy concerns. Okay. So can you avoid probate? And I guess if any of those issues were a concern to you, then an estate plan can be designed to limit the assets that go through probate or try to avoid it altogether. And there are major, let me think this way, the major ways that property is passed outside of probate. Here's the ways that you can avoid probate if you can help it, is by owning property jointly with rights of survivorship. Again, jointly with rights of survivorship. Survivorship is a legal term, and it can be added to almost any financial account, okay? And also even property owned. You can also ensure that the beneficiaries are properly designated. Let me use the word that's on the screen. I'm talking again about your IRAs, your 401k, the 403b, your life insurance, annuities, those things that allow for beneficiary designations. Please make sure they're right. If you put TODs and PODs on the rest of your financial accounts, you might consider using trusts, putting property into a trust, and that avoids probate because the trust document tells us what to do with it. So we don't have to have a court look at it. And then also you can make gifts during your lifetime and basically give it away before you pass away so that you can avoid probate. So I'm going to switch gears a little bit and talk about estate taxes. I know most of our clients are not going to be concerned with those right away, so I'm going to hit just a couple of examples. But my other goal as your financial advisor is I hope to make you wealthier. So at some point in the future, these might become an issue, and we may as well talk about them now. Okay, when we talk about federal like death taxes, sometimes we refer to them as a package of taxes. There's actually 3 types of federal taxes that are imposed when a property is going to be transferred from one person to another, either during your life or at death. They're referred to collectively as transfer taxes, and they include a federal gift tax, okay, the estate tax, and something called the generation skipping transfer tax. Okay, we're going to discuss these taxes on the federal level only. I want to make sure that you understand. Be aware, certain states also impose their own transfer taxes, and they usually affect smaller estates. So even if you are too small to get hit by the federal taxes, it is possible that you would get hit by your state's transfer taxes. Okay, so let's talk first about the federal gift tax. Okay, let me say it this way. If you, the donor, transfer property to another person, we are called the donee, during your lifetime, the transfer could be subjected to something called a gift tax. Okay, the reason there's a gift tax is just simply to prevent people from like giving their whole estate away before they die to avoid the gift tax, the death tax. Okay, gift tax does not apply to every lifetime gift though. So this is going to where it get kind of complicated. I'm going to try to make sense, but I'm going to keep it simple. And if you have questions, ask. This is really important. Okay. For example, in 2018, right now, you can give up to $15,000 to as many people as you want, gift tax free, under the annual gift tax exclusion. So every year you can give $15,000 to any person or any number of people and do it every year over and over again without paying a gift tax, but that's the maximum. Okay. By the way, the $15,000 figure is for this year. but the annual gift tax exclusion, they index it for inflation, so it can go up or down, usually up in future years, okay? Also, every one of us has a lifetime exclusion from all transfers. That's gift and estate, not just gift tax, but like your entire life, you can give away up to $11,200,000, and it is excluded from all transfers, transfer taxes, okay? That is, by the way, the largest exclusion in the history of the United States, but it's only scheduled right now to be in place for the next 7 years. It's scheduled to sunset, is what it's called, in 2025. So if you're not planning to gift everything away or pass away within the next 7 years, these numbers may or may not matter too much to you, okay? Let's talk about the federal estate tax, and this is the one that's commonly referred to as the death tax, okay? So let's assume that we talked about giving money away when you're alive, and here's what happens at death. When property is transferred at death, it is generally subjected to this estate or death tax. This is true whether or not the property goes through probate. Doesn't matter. It's all added together for the final estate tax return, okay? For example, even though you may have funds in an IRA that go right to the person because they're a beneficiary and it did not have to go through probate or through a court system, those funds are still potentially subject to the estate tax, okay? As with the gift tax, there are exceptions to the estate tax too. For example, property that you leave to your spouse generally is not subject to the estate tax because there's a full deduction allowed for marital transfers. So, and then also that same thing actually applies for charity as well. So you can gift. This is, by the way, why people, multi-millionaires are gifting into charity huge amounts, like Warren Buffett or Bill Gates. They create a charitable foundation, gift huge amounts of their personal wealth to the foundation, because you can gift to a charity and there's no maximum before you're taxed, okay? In addition, like we talked about just previously, every individual has a lifetime exclusion from gifts and estate tax combined. Again, that amount is $11,200,000. To be clear, though, that exclusion includes both living gifts and estates. So any portion of the exclusion you use for gifts while you're alive will not be available for you to give away tax-free in your estate, okay? There's also kind of a new cool feature for married couples that are in part of the new tax law, okay? It's very important for married couples to understand this. The exclusion that we're talking about, this $11,200,000 buffer, is portable. That's the legal term. That means that any portion of the exclusion that was not used by the spouse who died can be transferred to the surviving spouse, okay? So in prior years, this was not the case, but in 2018, they made this change. So now married couples with large estates, and they say they didn't give enough, the one person didn't max out their total gift before they passed away, the spouse now can take what was left of that their partner's $11.2 million and add it to their amount. So let's say a married couple can pass along up to $22,400,000 can be left to beneficiaries tax-free. I can't tell you how much of a significant change this was in tax law. It was huge, okay? But again, these higher limits do have a provision to sunset in 2025. There's just no promise that those things will be there in the future, okay? Now, the third piece of the tax system that I want to mention tonight is just the generation skipping transfer tax. And this is the way this works, as simply as I can make it, okay? In the world of estate planning, someone who is more than one generation removed from you, like a grandchild or even a great-grandchild, is referred to as a skip person, okay? If property is transferred during doesn't matter, either you're alive still or when you die, to a skip person, so to a grandchild, great-grandchild, there's a generation between you, then the transfer is subject to this generation skipping transfer tax, which is imposed in addition to the gift tax or the estate tax. And the reason that there is this generation skipping transfer tax is to prevent us from like trying to avoid the estate tax completely on our children. So like we were like, well, we'll move it to our grandkids and that'll do it. They said, nope, nope. If you're gonna skip a generation and give it all to your grandkids, we're going to impose this particular tax. Now, because the generation skipping tax, transfer tax is a separate tax, you get a separate exemption. So you can still transfer up to $11,200,000 to your skipped generation in 2018 without the tax kicking in. Okay. But unlike the gift tax and the estate tax, this generation thing is not portable, which means that if grandpa did not use it all before he passed away, grandma doesn't get to use the rest of it. Grandma gets her 11 million to versus and grandpa's is lost at that point. Okay. Here is a quick look at the different tax rates and exclusions for the last few years. For clients that are in this high range, this matters. For most of our clients, it's not. I'm going to kind of skip right over that. But now that you understand how taxes could impact your estate, especially if you become wealthy or your business booms or your property really appreciates in value, let me show you a couple of ways to help reduce them. And we're going to wrap up tonight. Okay. For one, the first one is to gift the money while you're still alive. We talked about that briefly. Okay. There are lots of good reasons to gift while you're still alive. One of the biggest one is you get the satisfaction of seeing the recipients of your gift enjoy your gift. Okay, that's probably the most important one. If you want to gift to your grandchild while they're going to college or something, you get to experience the benefit of that and their appreciation. So, but for many other people, gifting is used to minimize transfer taxes if they're very wealthy. And it's like I mentioned earlier, one way to do this is to take advantage of that gift tax exclusion that lets you give $15,000 to as many individuals as you want, tax-free. And there are several other gift tax exclusions that you can take advantage of. One of which is to, okay, here's a good reason why to do it, okay? Let's assume for a minute that you bought a house 50 years ago for $50,000 and now it's worth $1 million. Let's just say it appreciated something crazy like that. So you have, and let's say you want to give this particular property to your brother, okay? If you give the property to your brother while you're still alive, you do not get what's called a bump up in the cost basis of that property. When you buy anything, a stock or real estate, the original purchase price is what's called the cost basis. And here's the way that this is where the concern will be. If you gift a property that has appreciated in value significantly to another person while they're still alive, the law requires that the new owner has to keep the same original purchase price that you had. So, for example, you buy the house for $50,000 and it's now worth $1 million. You give it to your brother while he's still alive, and your brother sells it immediately for $1 million. Well, the law will say the original purchase price was $50,000. The sale price was $1 million. You now get to pay income tax on $950,000, brother. Okay. If you had waited for 1 year, so that's called no step up in basis. If you had waited, until you passed away, okay, and then your brother inherited that $1 million home, he gets what's called a step up in cost basis. So what the law will do then is say, what was the value of the property on the day you died? That becomes his new purchase price. So if it was worth $1 million when you died and he inherits it and sells it for $1 million, he had no real profit because he got a step up in cost basis. I hope that makes sense. I'm really trying not to beat that one to death. So, but that's one of the disadvantages. If you give it in your lifetime, they have to keep your original purchase price. If they inherit it after you die, they get the step up. Okay? Now, a quick note on how to make these gift transfers more useful. Okay? as we said, you can give 15,000 to as many individuals as you want. 30,000 if you and your spouse make the gift together, because each one of you can give 15,000. But if you are going to try to help fund a grandchild's college, and you have what's called a 529 college savings plan, you can actually give up to $75,000 at one time, or if you're married, $150,000 without gift tax free. Your accountant has to depreciate that over 5 years on your taxes, but you can do that in one lump sum. Okay. And here's a couple of really cool ones people are not aware of. If, let's say that your grandchild gets to go to Harvard or Juilliard or someplace very expensive, and the tuition will be more than $15,000 and you want to pay for it, there is no gift tax on amounts that are paid directly to the school for tuition. So instead of gifting it to the grandchild and letting them use it, you gift it directly to them for their benefit to the school. There's no gift tax. That same thing applies to help people pay for medical care. So you can do the same thing. No gift tax is paid if it goes directly to the medical care provider, and it can be even for their health insurance premiums. So you can actually gift without any kind of fear of taxes and help a child or grandchild or somebody pay for medical expenses. Okay, really important stuff. Now I'm going to shift gears again, because if you can't gift during your lifetime, I'm going to talk about two more things that we can use after death to accomplish the same kind of thing and minimize your taxes. The first one is called a trust. Okay, so a trust is, and I just want you to be very comfortable with this, and again, I'm going to be very basic tonight. A trust is a very common, probably the most common estate planning tool I see other than a will. And we've already seen a little bit of how a trust can play a role in planning for incapacity and to avoid probate, but trusts cover a lot of ground, and you may want to use a trust as part of an overall strategy to minimize taxes, to have certain property managed by a professional instead of leaving it to your family to deal with, to provide for minor children or elderly parents or other beneficiaries that you don't think may be able to make wise decisions with the money if they get it, or they might be taken advantage of by somebody else. If you're concerned about, for example, an elderly person with a caregiver in the home, that, there are actually stories about this quite a bit in the news right now of celebrities who have handlers who are way too close to them, and people are concerned that handlers are taking advantage of them financially. Okay, so a trust can be done to where you can still gift to that person, but another person called the trustee will administer that money for you. Okay, also certain trusts provide a means to protect your assets from future creditors, because the trust owns the assets now, not you. Okay, and this actually is, for some people, a concern that it allows you some control over the property and assets that you've generated in life, even after you've died. Okay, and I can give you a very quick real life example. I had a client who was a client for many years. He had an estate of about $3 million and passed away about 4 years ago. And we went together to an estate planning attorney in Brownsville and created his trust and put all of the money in the trust. And the reason he decided that is, even though he only had one son and two grandsons from that son, and he wanted the money to be 50% to his son and 50% to his grandsons, his grandsons were only in their early 20s. And he was very concerned about his 20-year-old grandson getting his hands on $750,000. He thought he would blow it. He's like, this is my chance. I worked so hard, all 80 years for all of this. I want to give this to my family. It's my last act of love, but I don't know that they really, at that age, he goes, when I was 20, I would have blown it. I would have bought nice cars. I would have done stupid stuff with it. So he wanted to make sure that the money was set aside for later use for his grandsons after they matured a little bit. So we created a trust that allowed his son to get his right away, and the grandsons would get a little bit of an amount per year out of the trust, and then they would get 25% when they were 30, 25% when they were 35, and the rest when they were 40. And the trust terminates when the youngest grandson reached 40. Okay, so you can do those things. And that allowed him some comfort that he goes, by the age of 40, hopefully they've got all their wild oats sowed and they're more responsible. By the way, this money is still growing in the trust because it can be invested. It can be significantly more money than it was if I do this. So he didn't want to control the money from the grave, is the way he described it, but he did want to make sure that it was going to be used in a way that was responsible. And he wasn't sure that a 20-year-old could do it. Okay. So let's talk about just kind of what a trust does. And I'm not going to, again, beat this to death, but I want to make sure that you understand kind of the legal framework and how a trust is constructed. So a trust is just a legal entity where somebody who's called the grantor, let's assume this is us we're talking about, we're making our estate plan, arranges with another person who's called the trustee to hold property for the benefit of the third party who's called the beneficiary. Okay, so the grantor names a trustee who is going to manage property for the beneficiary. Okay, so when you create a trust, you actually split the ownership of the property in the trust. Legal ownership goes to the trustee, and beneficial ownership goes to the beneficiary. So this means the trustee is legally responsible for managing the property according to the rules that you've set up in the trust agreement, and the beneficiary gets all the benefit of it. Hope that makes sense. Okay, a trust that you create while you're alive is referred to as a living trust. Makes sense, right? A trust that is created upon your death, for example, like in the will, it may say the trust is going to be created in the will, it's called a testamentary trust, but that's the difference between the living trust and a testamentary trust. And if you have the right to change the trust or end it at any time you want, it's called a revocable trust. Okay, if your trust is written in a way that can never be changed, that's called an irrevocable trust. And just so you know, most revocable trusts become irrevocable at the moment you die anyway, since you're no longer around to change the trust or revoke it. It becomes irrevocable. Okay, I'm not going to go into more detail about that, but just in a brief sense, a revocable trust, if you ever talk with anybody about it, is commonly used to plan for incapacity, because you might change your mind on what kind of medical care you want, and to avoid probate. The irrevocable trust is usually used, in my experience, to worry about transfer taxes and protecting something from a creditor. So, we're concerned about that. Guys, I know I'm about 6 minutes over. I've got only a couple more minutes to go and we'll be done. Okay. I want to talk to you very quickly about one way that life insurance can play a part in everyone's estate plan in one way or the other. The first obvious one is if you don't have a lot of money and you don't have an estate, well, if you have a life insurance policy, that creates an instant estate. When you pass away, life insurance sends your beneficiaries a check. That created it. Okay. Another reason is because life insurance, a lot of people, especially my Texas clients, like to buy real estate. That's not easy to sell right away. So if most of your wealth is in real estate, your heirs may have need for some immediate cash to pay for any outstanding bills you have, any taxes that are due, your final expenses, those kinds of things. And they don't have to do a fire sale or like lose money on the real estate. It buys them time to liquidate the other assets in a way that maximizes value for them. Okay. Life insurance proceeds can also be included in your estate just to pay the tax. Some people buy the life insurance. They go, okay, I got this huge family business. I don't want my family to have to sell it to pay the tax. So let me buy enough life insurance on me that when I die, the life insurance will pay the estate tax. And that's done as well. Okay. And also, the biggest issue on life insurance is really knowing when you use it inside a trust to make sure it's legal, is you have to make sure that ownership of the policy is really key. So let me give you one quick kind of cool example of how life insurance can be used in a trust to create an estate that doesn't affect your estate tax maximums. Okay, let's assume. So it's a common strategy. It's called an irrevocable life insurance trust. Okay, but let me give you an idea of how it works. You create an irrevocable trust. Okay, you name someone as a trustee and you name your beneficiaries. Okay. The trustee then buys a life insurance policy on your life. Okay. Follow me along. Okay. Everybody stay awake. I know it's late. But the trust owns the life insurance policy, not you or not anybody else. The trust does. Okay. So then you make regular cash gifts to the trust to make the life insurance premiums, to pay for the life insurance. Okay. The trustee by law has to notify your beneficiaries that you have contributed to the trust. The beneficiaries technically have the right to withdraw that cash gift, but they don't, because withdrawing the gift is going to defeat the purpose of the trust, which is to create a much bigger amount of money for them at your death than the cash gift would be to pay the premium. Okay. So then after that time period where the beneficiaries can withdraw but don't happens, then the trustee uses the cash to buy the insurance premiums. Okay. So that's how that's done. Now, what happens when you die in this kind of a situation is the trust receives the proceeds from the life insurance policy because the trust owned the life insurance. The trust was the beneficiary, but the trust document then says, disperse it to the beneficiaries the way that we wanted. Because the trust owned the life insurance, the proceeds were never part of your estate, so they will never be subject to the estate tax. Okay? And then they are then distributed to your beneficiaries the way that you had it described in the trust. And they will receive the full proceeds free from estate tax. So that's some of the cool ways that you can do some really neat financial estate planning in creative ways. So this is something that estate planning attorneys do very well. As your financial planner, I am well versed in it, but we don't create those documents for you, but we can certainly steer you to and participate in the creation of those documents for you. Okay, here's our conclusion, and I really appreciate the time everybody spent with me tonight. As we wrap up, I want to take a moment just to ask yourself these couple questions. Have you implemented any kind of plan in place if you become incapacitated? By that, I mean your plan to deal with your health and your property. So please give that some thought. Also, do you have a will? If the answer to either of these questions is no, there is no more time to waste and we have no more excuses. You need to address the issues with me as soon as possible. I'll help you get them done, maybe even for free. Okay? So then the other question is to ask yourself is if transfer taxes are an issue for you. I don't think most of my clients who are participating tonight, that is an issue, so we'll leave it there. But finally, if you do have an estate plan, is it current? Does it reflect your current wishes and the circumstances of your life now? Have you remarried? Are you divorced? Things like that have to be thought of, okay? Are your kids grown now? Ours were still listed as minors on all of our legal documents, and they were no longer minors. We still had a guardian listed for our kids, okay? Finally, I want you to schedule your review appointment with me today, and we'll knock this out together, okay? So here's your action plan, my beloved client family, okay? If you have no documents yet, please, let's get them done this month, and I will help you, and you might even be able to do it for free, but they're not that expensive, especially if your situation is not complicated. But even if it is, this is one of those things you can't afford to ignore, okay? Not for your family's sake. If you already have estate planning documents, just make sure they're up to date and you don't need to make any changes, okay? Please review your beneficiaries on all your accounts. This is what we want done this month for all of our clients, okay? Get to your bank and any brokerage account that is not with me, and I'll make sure that the ones with me are have TODs and PODs put on them. Make sure that your payable on deaths, transfer on deaths are on your bank accounts. Take a couple minutes, just ask for the form next time you stop into a bank. Get the form, fill it out, hand it back, it's done. Okay? Then I want you to gather all these documents. We'll scan them up, and we will put them online, and we will keep them for you, and we will even let you appoint a family member or CPA or attorney and give them access to these documents so that they can access them anytime if anything happens. Okay? We'll do that for you. No additional cost to our clients. So that is it tonight. I just wanted to give you just a sneak preview for next quarter, and I hope that you enjoyed this webinar. We're going to make sure that we leave it up until the end of June so you can refer back to it. Make sure you get your workbook. All of this is in it. Next quarter, we're going to break you guys up. This was an all-client event this time. And the next quarter, we're going to actually split you back up into your different life cycles, okay? In July, our established investors, and you're going to get an invite for this, we're going to dig deeper into this subject and do advanced estate planning and some strategies there, okay? In August, my emerging investors, which are usually pre-retired, the Gen Xers kind of thing, you're going to be learning the ways to maximize the growth potential of your 401k or your 403b to make sure that retirement is now your focus. We're going to really hit that hard in August. And then in September, for our early investors and our employee investors, just right in time before your company's open enrollment for benefits happens in the fall, we're going to make sure we teach you all about the healthcare options and the other benefits that you may have available to you, what an FSA is, what an HSA is, high premium, low deductible kind of health insurance, help you make the right choices for your family, let you know what's junk that you don't need and what's worth the money. Okay, so we're going to talk those things out. I really hope you guys had a very good training session. Again, keep your notes handy, bring them to me, and please schedule your follow-up call with me. About 15-20 minutes, and we'll put a plan of action in place to knock down this estate plan once and for all, okay? I wish you all a very good evening. God bless you all. I wish I could see you. It's always great to talk to you all. Have a great night, okay? Talk to you later. Bye-bye.